That's working on court.
All right, so what are we here for?
Judge, we're here for
For
a
restitution?
hearing.
Yes.
Unfortunately, Judge, we've had some problem with making contact with our complaining witness after the plea. I've spoken with the approving counsel. We're okay with doing a short reset to next week. I should have something back by the end of the day, and then we can meet next week via Zoom. If the court will allow.
Your Honor, I have no problem being here. I just asked that if my client be allowed to join via Zoom, that would be
Yes.
appreciated. Beautiful.
All right, Norm, I need a reset date for restitution. They're saying next week, give them 2 weeks.
I can do August 13th.
All right, August 13th, and the defendant may appear by Zoom. You're welcome. And counsel, if you'll just let your client know when you're present, so they won't be on Zoom for a long time.
Yes, ma'am. I will coordinate. And he was on time, so I feel better.
All right, thank you. Once you sign the reset form, you're excused. Robert Maurer,
We're
what's?
good. Rick's gonna enter her number. He talked to her. Hopefully the dialing 1-900 numbers on my phone.
Okay, so Rick has already talked to her?
Yes.
Okay,
I talked with her and she said she wants no contact order lifted. She wants it to now.
all right, let's come forward.
Love Bloom.
All right, we're back on the record in 2026 CR 008220, State versus Javier Olvera. Can I have parties re-announced for the record?
Rick Painter for Cedar, Texas.
Robert Mauer for defendant.
All right, and you, Mr. Olvera,
Yes.
did you review the plea bargain page with your attorney? Did you understand it? All right, so according to the plea, punishment is to be assessed at 6 years in prison, $1,500 fine. State is recommending community supervision. There's to be no harmful or injurious contact with the complainant. Did you understand that to be your plea?
Yes, sir.
State defense?
That is a plea, Judge.
Yes, Your Honor.
All right, and state, with regards to this no harmful or injurious contact, did you have a chance to speak with the complainant?
I did just consider, Your Honor. I asked her a series of questions and after a series of questions, she basically does not want to have more.
All right, and is that correct, counsel?
That's correct.
And counsel, I believe you stated earlier that she had also filed an affidavit of non-prosecution.
Yeah, I don't have a copy of it. She might have provided it to SAPD, but I know she had indicated that she wanted to drop the charges. I think that's why she wasn't responding initially.
Okay. All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years, 200 hours community service restitution, anger management, TAP evaluation, follow all recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. Please send the state bill offering-
No objections.
Exhibit 1 for its actions.
Okay. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And state, you may be excused.
Thank you, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Off the record. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty And the court will find you guilty. Are we proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, I just asked the court to grant his application. He's been incarcerated for 5 months on an off bond. So I think he's ready to get on with his life.
How old are you?
56, ma'am.
All right. Here's the thing, you're gonna be in probation out of this court. She is saying that she wants you, I guess, to move back in with her. You know better than I do what your relationship is like.
Yeah.
Maybe this is a relationship where you all shouldn't be together. You understand?
Yes, ma'am.
Because if the court receives a phone call that you violated the court's orders, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
All right. When's the last time you had employment?
I worked all my life, 25 years.
He does concrete work, Judge. He's just been unemployed since he got incarcerated.
All right. Are any children in that household?
No.
All right. The court is finding you guilty. The court will sentence you to 6 years in prison, suspended and probated for 6 years, regular reporting by Zoom or in person, regular random UAs, TAP evaluation out of custody, follow recommendations. However, if TAP recommends inpatient treatment, we'll start with outpatient treatment. There's a $1,500 fine that will be probated. There's to be no harmful or injurious contact with Marella, Mariela, Barrera. Field visits 1 time per month for 3 months. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. No residing in households with minors. 200 hours of community service restitution. The court is going to order anger management. Once anger management is completed, the community service hours were deemed satisfied. No possession of firearms. This is a conviction, and it's felony conviction. You're not allowed to own any firearms. Do you understand? Okay. Probation, is there anything else?
No, ma'am.
Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right, good luck to you. Make better decisions.
Thank you, Judge.
And do you have the other?
No, it's.
Print out.
I'll get that.
Thank you.
So,
Oh, yes.
And then also.
Page you say on?
He's on page 5, 1 down.
All right, Azula Ziermel.
Morning, Judge.
Morning. Oh, he needs to come down.
That's the one.
Oh, if you'd have put that goes to just for that last case. All right, good morning.
Morning.
So you just repeat everything that I'm saying. All right, so what is happening today?
Judge, we'd ask for a reset so I can further investigate some of the things I've learned today.
All right, do you have any questions?
No, no, no. No, no.
And how long is this going to take?
Because of the language issue, probably at least 45 days.
All right, so did you tender an offer?
Yes, Your Honor.
Oh, if you could speak up so I can hear, I love different languages. And so, let me hear is it Persian?
It's Pashto.
Oh, yeah, let me hear the language. All right, so how long would you all expect this jury trial to last if it's a trial? Because he has two cases.
Correct. Obviously, the assault case is the more pressing case. It'd probably take a whole week.
All right, and all right, Norma,
Yes, ma'am.
and I hope you'll be available. If you will not be available, let me know. Norma, set this for a jury trial and a plea deadline date in 60 days.
Thank you, Judge.
All right, are you available?
I'll be available.
September 28th?
Yeah, I'll be available.
All right, so they're gonna give a reset form just so you'll have it. And so we'll need you for that entire week if they decide to go to trial. All right, thank you so much.
So much.
Thank you, Judge.
You're welcome. Oh, and sir, if next time, I'm sure if you need the headphones for him, just let us know. And I know that the interpreter upstairs will be more than willing to provide that for you.
I'll be over there because I had a last file and we used that. It helped a lot.
Okay.
Yeah, thank you so much.
You're welcome, thank
Thank you.
you. Who's next?
It is Lacey Wheat, page 3, one down.
Lacey Wheat?
And I didn't get one to leave. They took it to him to the back, sign it, and then I think it's his copy.
And Norma, you have the interpreter's number?
The one that has it is the Travis is the one that in contact with me.
Okay, it's your, if you'll make sure they know the name.
You know, I'll fight today.
All right, thank you.
Different.
Good morning. How are you doing today? What's the tears?
We're working towards resolving this ordeal for her, Judge. It's been a lot of stress on her.
All right, so where are we on resolving this?
Still outstanding discovery, no CPS as of this date. Last court, we did bring that to light for the court, so we can have that. And I was just informed by the state today that they do not have that in their possession. So that's.
Right, the CPS matters, is that from Bear County? Can somebody pick up and call the prosecutor on the CPS side and just say, hey?
That's what I was kind of suggesting. I did speak
Because
with. Go ahead, Judge.
No, because if there's a CPS matter that's ongoing, the prosecutors over there will have the CPS records.
Your Honor, I believe at this stage, it is delaying the proceedings. I know the DA's office has a number of investigators, paralegals, as well as attorneys, and the fact that we do not have that at this date is concerning for me and my client in deprivation of her due process rights, Judge. We did file a writ of habeas corpus pursuant to 17.151 due to this delay. She is in custody and she has been in custody on this alleged offense.
All
And
right,
we
let's
also.
do this. Let's recall this. We're gonna recall this in 2 weeks. CPS records, they need to have them. If they don't have them, then we can take up whatever matters you wish to take up and the court will hear whatever motions you have.
Yes, Your Honor.
All right, and the reason why I'm giving the extra time is because we were here June 16th about the CPS records. And I understand sometimes CPS records, if they're not ordered, when whomever was in intake doing this, there's an issue. So we're gonna come back in 2 weeks to get that done. August 13th, and then what is her bond?
Her bond is set at $150,000, Your Honor, and we did file a motion to reduce that bond. And my client is asking that the court consider reducing the bond. I know typically these type of cases, $150,000 is an extreme amount.
All
My
right. Are y'all ready to proceed on the motion to reduce bond?
We're gonna stand down because that bond was not. Extra, there's that bond. That's grand jury. We're gonna
Well, I mean,
take
let's
your
not-
honor to
I would say the grand jury doesn't.
decision on that.
The grand jury doesn't have a lot of insight as to how legal matters work. They're lay people, aren't members of the community, so.
Well, let's not stand silent. I'll still need some evidence. So it's noon. Are you able to come back this afternoon?
Yes, Your Honor.
All right, so we're gonna come back on Miss Lacy this afternoon at 1:30 to hear her matters.
Thank you, Your Honor. We'll be to hear
Thank
that.
you.
Thank you.
Ms. Lacy, Judge, you can do the.
Okay, let's do that. All right, the court is gonna take up this matter, then after that, we're going on recess. So, Keyshawn Merritt. And is there an application?
Yes, ma'am.
And is it opposed?
Yes.
All right, I need a PSI date, please.
Yes, ma'am. Give me 1 second, Judge.
Hello. Is there going to be a need for a tap?
We'll take one.
All right, probation.
Yes,
It's gonna be a PSI and tap evaluation on Keyshawn Merritt,
Thank you.
and it's gonna be set for September 14th. And is there a need for any mental health evaluation?
We'll take one as well.
All right, and it's gonna be a MIC evaluation as well.
Yes, ma'am.
Court is calling 2025 CR 015747C and 2025 CR 015750B, State versus Keyshawn Merritt. Can I have parties announced?
Let me grant behalf of Mr. Meredith to my right.
And are you Mr. Merritt?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
To the best of my knowledge, and yes.
Court will find that the state is in compliance with discovery. Mr. Merritt, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment in each of these cause numbers with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading?
Yes, please.
State, are you proceeding on the indictments as presented in each cause number?
Yes, sir.
Mr. Merritt, did you review the court admonishments in each cause number?
yes, ma'am.
In the cause number ending in the letter B, you're charged with robbery. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication in that case, the court could find you guilty if a motion to revoke were filed. The court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine. In the cause number ending in C, in counts 1, 2, and 3, you're charged with aggravated robbery. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication, will revoke, the court could find you guilty and sentence you to life in prison in counts 1, 2, and 3, and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause number? Counsel, has your client been Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes,
Mr. Mr. Merritt, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas? Anyone promised you anything other than the plea? Satisfied with the way you've been represented? If you're not a US citizen, by entering these pleas, you will be deported, denied naturalization, and reentry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain page with your attorney? Did you understand it? All right, according to your plea, the cases are to run concurrently. The state is taking in consideration 2026 CC 006-033, 2026 CC 12013. The state is opposed to your application. And of course, counts 1, 2, and 3 will run concurrently. There's a cap of 15 years in each case in the prison, $2,000 fine. There's an affirmative finding of deadly weapon in the cause number ending in C. Did you understand that to be your plea in each of these cause numbers?
Yes, ma'am.
All right, state defense. In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Then in the cause number ending in the letter B, how do you plead? Guilty, not guilty, or no contest? And in cause number ending in C, how do you plead to count 1?
No contest.
To count 2?
No contest.
To count 3?
No contest.
State any evidence to support the defendant's plea.
No, Judge.
All right, state you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there's sufficient evidence to find you in each count guilty and in each cause number guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. We will come back on September 14th. At that time, I'll base my decision on whatever evidence is presented. With regards to the PSI, TAP evaluation, and MIC evaluation, probation will probably see you more than one time. Just make sure you speak to them. Counsel, if there's an issue with the jail, as far as maybe there's a different rotation or something and they don't get a chance to see him, just let the court know and we'll make sure it happens.
Thank you, Judge.
All right, good luck to you. You're welcome. Thank you.